Hello, everyone. Thank you for joining us today. Happy Thursday, and welcome to the ACLU of Pennsylvania's All Membership webinar. I'm Reggie Shuford, and I have served as the Executive Director of the ACLU of Pennsylvania since 2011. I use he, him pronouns, and I want to start by thanking you all for joining us today. The work that we do as an organization to advance civil liberties takes all of us, staff, volunteers, clients, community partners, and supporters who are dedicated to fighting for a Pennsylvania that is better for all of us. We appreciate all that you do to advance our work. One of the things that is important to us as an organization is increasing the diversity of our organization in every aspect. That includes membership, so that it reflects the world that we live in. With our member calls, and we do these a couple times a year, there's often a broad range of folks who call in. Some of you are familiar with and have been supporting our work for decades, and some of you are newer to the organizations. We appreciate you all. So we always like to take the first few minutes of these calls to provide a broad overview of our organization and the work that we do, especially for those who are newer to the organization. So to that end, the American Civil Liberties Union is a national, nonpartisan organization founded over 100 years ago. We do not endorse candidates for office. Here in Pennsylvania, we have a staff of roughly 40 folks, with offices in Philadelphia, Harrisburg, and Pittsburgh, and have over 40,000 members across the state. Nationwide, that number in terms of membership is approximately 1.75 million people. Here in Pennsylvania, our priority areas are decarceration, police reform, and voting rights. So although 70 to 80% of our work will be geared towards those top three priorities, the rest of our time is designed to allow us to be nimble, to be able to respond to other emerging threats like reproductive rights, for example, and LGBTQ equality. All of our work, indeed every aspect of the organization, incorporates what we call ABIDE, authentic belonging, inclusion, diversity and equity, and racial justice. I continue to be proud, very, very proud of my colleagues who live in this work and do it day in and day out. It's not easy work to do at all. With that said, I will say something else that is a bit hard for me to say, which is that today is bittersweet for me. Some of you are aware of this, and others may be hearing this for the first time. After 11 years at the helm of the ACLU of Pennsylvania and 15 years as a staff attorney in the national ACLU, I've answered the call to return home to North Carolina to continue my social justice advocacy work. I will become executive director of an organization called the North Carolina Justice Center, which is a progressive anti-poverty nonprofit organization, and I'll start there in mid-February. It was not an easy decision at all. But oftentimes, as I think we all know, the big decisions are not easy. Things are going so amazingly well at the ACLU of Pennsylvania. We have a great staff and an amazing board. We do such impactful work. And thanks to my colleagues, we do it, some of whom you'll be hearing from, we do it really, really well. So it was a really hard decision, but it was almost impossible for me to ignore the call to return to North Carolina to do very vital work there too. But thank you all who've supported the organization over these many years, and for those of you who have impacted my tenure over the past 11. That is not why we're here today. We're here to get you some CLE credit. We're here to talk about the ACLU of Pennsylvania's legal year in review. Suffice it to say, we've been very busy. And so we're going to hear from three of our colleagues. Initially, we were going to hear from four, but our colleague, Alex Domingos, is not feeling that well. So he's feeling a bit under the weather, and we told him to not sweat it, take the day off. and that the rest of us will do our best to update our listeners and everybody on the call in terms of the work that we've done over the past year. Alex, I hope you are not listening. I hope you're resting, but I certainly hope you feel better. So a few logistics. I'll be guiding the dialogue today. In a bit, we'll bring our panelists to the stage and spend about 40 minutes or so discussing what we've been up to this year. And we'll be sure, of course, to leave time and space for Q&A at the end. So for folks who might have not seen this, just as an FYI, today's webinar is being recorded. We'll plan on posting it as well. So please feel free to share that when you receive it, just so that you can help others kind of become more familiar with our work as well. If you need closed captions, you can enable that feature at the bottom of your Zoom screen under live transcript. We will be utilizing the Q&A function and chat during the call, so please use them. We want to hear from you, of course. And for folks who've dialed in, you can submit your questions to donate@aclupa.org. And if you are, in fact, seeking CLE credit for today's event, please note that the CLE passwords will be announced twice per hour, as my colleague Sarah Johnson mentioned at the top of the call. Please write down these passwords and enter them on the survey after the webinar. The survey is mandatory to receive CLE credits. These passwords will let us know that you participated and for how long you participated. So the first password, be prepared to write this down, is civil rights. I think that's in all caps, so try all caps. But the first password is civil rights. Okay, so with that said, let's welcome the panelists. All right, that was like a 1, 2, 3. Steve, Rich, and Marian, welcome. So good afternoon to you all too. I'm pleased to be here to help guide this discussion and this important dialogue, talking about the legal cases, et cetera, that we've been involved with this past year. So Alex, you're not here. We'll be doing this in your honor. Marian, Rich, and Steve, thank you so much for joining us today and sharing your expertise. So to get the conversation started, I want to start by myself as moderator asking a few questions of each of you. Then after that, as I said, we'll open the floor for questions from the audience. Just as a reminder, again, you can submit your questions at any time using the Q&A feature at the bottom of the Zoom screen, the chat, or through email at donate@aclupa.org. I'm just going to ask the panelists who I don't have the time to do a more formal introduction that the first time you speak, you'll say your name and your pronouns and your title at the organization. All right. So taking a deep breath, but it's been a year, right? It's what a year it's been. And I think we're still processing some of that. But as an organization, we have been very busy. And certainly our legal staff have been quite busy. So I just want to start by asking you, and I'll even start by answering the first question I'm going to ask each of you, but what are you most proud of over this past year in terms of the work that either you did personally or the organization did writ large? I'm going to say, as proud as I am, to just sort of start answering that question myself, as proud as I am of the amazing work that we did and have been able to do at a really consistent level, notwithstanding, right, the world's issues and the external challenges of a pandemic and so on and so forth, that we were able to continue to do that work at such a high level. So that's both the legal work, obviously, but all the other work of the organization too, the advocacy, the comms work, the fundraising, like all of it has been done at a very high level, notwithstanding all the challenges that we as an organization face, but also just what we as Americans faced as well. I'm proud of the growth of the organization. Certainly we've had to grow in order to keep up, right, with the work that is demanded of us. And I'm also proud, this was certainly a high priority of mine when I started in this position 11 years ago, of how we've diversified as a staff. There was very recently at one point, half of our staff were people of color. And we achieved that, right, through being quite intentional in terms of our hiring processes, but also in terms of the culture that we try to create here at the organization. So those are some of the things. Like I'm proud of all the cases that we did, like the high volume of them, the success of those cases. But yeah, I'm gonna stop right now. I'm gonna ask you all to chime in with what you have been most proud of over the past year. And does any one of you want to go first, or should I just call on you randomly? You know, I'm going to call on you randomly then. So, Rich, I'm going to start with you.
Thank you, Reggie. I was about to say, I think it's probably easier if you just call on somebody, but so hello, everyone. My name is Rich Ting. I'm a staff attorney. I use he, him pronouns. I'm in the Pittsburgh office. And I'll say in terms of the legal work that we've done this year, I think what I'm most proud of is the work we did in Central Bucks School District regarding a hostile environment for LGBTQ kids in the school district. I'm going to be talking about that in more detail later, so I'll hold off on saying more.
Thank you, Rich. I understand why you're proud of that work. Marian, I'm going to turn to you now.
Oh, hi, everybody. My name's Marian Schneider, and I'm the Senior Voting Rights Policy Counsel at the ACLU of Pennsylvania, and I use she, her pronouns. And I just want to mention a case. I mean, there was so much litigation this year in voting rights, but one of the cases that was kind of voting rights adjacent had to do with the Sunshine Act, which is a really important tool for ensuring accountability in government. And before the primary, the Lancaster County Board of Elections decided that they were going to remove the county's only drop box. And they did it at a meeting that they didn't tell anybody that's what they were going to do. And so we went into the Court of Common Pleas in Lancaster County and got an order requiring them to properly notice the meeting and to put it on the agenda to give notice to Lancaster County citizens that they were going to consider removing the drop box. And there's very little case law on the Sunshine Act, so that was a really good decision. But I just the judge's second paragraph was so poetic. And coming out of the Court of Common Pleas of Lancaster County, I feel like it's something to be read. And he said, in 1644, the Reverend Samuel Rutherford published the provocative book Lex Rex. The book was provocative because of the order of the words, Lex, the law, being placed before Rex, the king. And throughout his book, Rutherford argued that the king is not above the law. The principles espoused by Rutherford became one of the underpinnings for the rule of law in the United States. No person or group is above the law, and justice cannot be administered based on any factor other than what the law says. That was a great decision, and I say amen. And that's one thing I'm proud of this year.
I say amen too, right? Because we've been seeing the rule of law come under serious attack in these past several years, especially. So amen indeed. Steve, what about you in terms of what you're most proud of over this past year?
Thanks, Reggie. And for those who don't know me, I'm Steve Loney, senior supervising attorney, sitting in the Philadelphia office. I use he, him pronouns. And this has been my first year with the ACLU of Pennsylvania. I started at the beginning of the year. So I am very proud to be part of that growth that Reggie was talking about earlier, and to be part of all of the remarkable work that's going on here. And I will just add to in talking about the growth of our organization, also the thanks to the force multipliers we have out there in our co-counsel in our last fiscal year, which closed earlier this fall. I think we had 112 cooperating attorneys during the year who donated almost 10,000 hours in total. And that doesn't even account for what happened right after the fiscal year closed and all the volunteer attorneys who helped with election protection work and threw in with us on litigation needs for the election. So thanks to those of you who are part of that. But to name a specific case that is actually not part of one of our top 3 priority areas that I'm really proud of is our work for the Abortion Liberation Fund this year. Obviously this is a critical time for reproductive rights. Although I've heard some folks say, I think mistakenly, that Pennsylvania still has reproductive rights at the state level. So maybe there's less reason to worry here. But The picture here is still very flawed, and the rights of those who can become pregnant is still under attack in our Commonwealth, not just at the national level. And one attack came earlier this year when a group of well-known anti-abortion activists tried to stop the city of Philadelphia from giving a much-needed $500,000 grant to the Abortion Liberation Fund of Pennsylvania, which was to help pay for abortion care for Pennsylvanians who can't afford it on their own. And these activists came in from another state, found some anti-abortion activists in Philadelphia to file a lawsuit seeking an emergency order to stop ALF from using those funds. They allege that the grant violated laws that prohibit use of state and federal funds to fund abortions. And we sprang into action. And again, thinking about co-counsel, we got a group of terrific lawyers from Ballard Sparks who worked with us. We appeared on behalf of ALF, and we worked alongside the city of Philadelphia to push back against the plaintiffs who had really no valid legal claim against our client. And the case has nothing to do with state and federal funds. It was all city funds being used to as a grant to a nonprofit to serve its very lawful and laudable mission. We got an order denying the injunction earlier this year from the Philadelphia Court of Common Pleas. So ALF gets to keep the money. That decision is pending an appeal, but so far we've beaten back the attack at every turn. So I'm very proud of that.
Awesome. I'm proud of that work too. And I just, and using my prerogative as moderator, I'm just going to have to editorialize a little bit. I know how very busy all of you all were working on that case, but even if folks are under the misconception that all is well in Pennsylvania with respect to reproductive rights, we all know that not everybody equally has access to those rights. And a lot of work remains to be done to make it more accessible, that right more accessible to people. So I'm happy we were able to get to do some really important work on that case too. So earlier I discussed the three core priority areas of the organization that we've been spending most of our time and resources on. One of the emerging threats, though, that we have responded to this year has been defending students' rights. And we've been working, for example, in the fourth largest school district in the state. Is that Central Bucks, Rich? So which is what Rich talked about earlier, just briefly. Along with other places in the state, it's not just Central Bucks, on ensuring an inclusive educational experience for all kids. I think everybody on this call, today's meeting, certainly are aware of all of this, so many of the situations where this has become like a big deal, not just in Pennsylvania, but around the country. But Rich, could you talk a bit about that work? You alluded to it earlier. I'd like to give you this opportunity to go into a bit more detail.
Yeah, thank you. And it's too bad that Alex isn't feeling well, because he did a lot of the work kind of organizing and kind of starting our investigation on this. So basically what happened earlier in the year, we started hearing from different parents, community members in Central Bucks about kind of different things that have been going on in the schools, and mostly about transgender kids experiencing a lot of harassment and bullying in the schools, and the school district not really doing anything to respond to it. So that, from that, we started getting connected with more and more people. And again, Alex was really integral in that work. And as we started to talk to more people, we started hearing a lot of very similar stories. We talked to a lot of students, their parents, we talked to teachers, and it kind of developed this picture of what was going on there, that there was a pervasive problem of bullying for transgender kids, and the school district was well aware of it. And when parents complained, nothing happened. So eventually in the fall, in October, we filed a complaint with the U.S. Department of Education Office for Civil Rights, OCR, on behalf of 7 transgender and non-binary students who, again, all of them had experienced different forms of harassment and bullying, and The legal theory of the complaint is based on Title IX, which prohibits discrimination on the basis of sex. And one form of discrimination is a hostile environment, where the school district is aware of the hostile environment and does not do anything to correct the problem. And what we saw in Central Bucks was not only did they ignore the complaints from the parents, but they were passing policies, adopting policies, taking actions that were actually making the situation worse. So, for example, there was a directive for teachers to remove pride flags from classrooms. Now, we did see that was kind of unevenly enforced, but we do know for sure certain teachers, it seemed like, that had larger pride flags were specifically told to remove pride flags from their classrooms. And also the superintendent and board president released a very lengthy public statement saying that pride flags do not belong in classrooms because they're political, whatever that means. They also instructed teachers to not honor students' requests for pronouns unless it matched what was in the school's internal system. And if a student did make a request for a name or pronoun change, they had to be referred to guidance and would have to get parental permission to have any of those requests honored, even if the student said, no, I'm not comfortable telling my parents because it won't be safe for me at home if you do that. So those are just a few examples, and there are really a lot of other things happening there, and things are still going on. The good news is OCR opened an investigation. I don't have a lot of updates on what has happened since then from OCR side. We do know they've requested a lot of records from the school district. The school district, a little bit disappointing. I guess we didn't have high hopes, but we had hoped that they would at least, kind of pause and back down. But unfortunately, it seems like they're doubling down on their positions. Just last night, they had a policy committee meeting where they went forward with a new policy that would restrict what teachers are allowed to say in the classroom. And basically, they would not be allowed to advocate for any partisan, political, or social policy issues, which is horrifically vague. And it's clear from public statements that they're targeting things like pride flags and discussions of sexual orientation and gender identity. They also hired Bill McSwain, which many of you probably know was a Republican candidate for governor. They retained him to represent them in this investigation. While he was campaigning for governor, he made a lot of kind of anti-LGBTQ statements. He criticized the middle school GSA. So it's a little bit disheartening that that's who they chose to represent them in the investigation. It kind of shows that they're not going to back down from their positions, but we're still hopeful that OCR will be able to put some pressure on them. The kind of leverage that OCR has is Department of Education. If they determine there's a violation of law, they can withhold federal funding from the school district.
Thank you. One of the things you said was about doubling down, right? And it feels like that's like a common response these days to many of these issues. And, we have amazing lawyers on our staff, and an important and effective strategy always has been for us to send a really strongly worded letter and then lots of people back down, right? Which frees us up to do other cases where folks aren't. And people are doubling down a bit these days. So we have to definitely be ready and prepared that once we start to see it all the way through, and who knows, that could be on to the Supreme Court, as we've seen in a couple of other cases recently. So here at the ACLU, we work day in and day out on ending really harsh policies and the racial inequities that are so deeply embedded in our criminal justice system. The rights that are guaranteed to the accused, to defendants, offenders, and prisoners are really fundamental political rights that protect all Americans from governmental abuse of power. These folks are often the least popular among us, but their rights are deeply enshrined in the Constitution, and they're important to uphold. So this area is an important priority for us. They include the right to a reasonable bail, the right to due process of law, and the right to be free from cruel and unusual punishment. Because it's a priority, the work takes up, appropriately a significant amount of our staff time. And it really crosses over a wide variety of areas of the work that we do, including decarceration and police reform. So during my tenure, I've been proud of the work that we've been doing with respect to criminal justice reform. But again, given who the population of people are, it's never been easy. And this year's just not been any different from that perspective. So Steve, do you mind sharing with us some of the work the legal team has been doing over the past year in the criminal justice reform arena?
Sure. And there's a lot to talk about here, so hopefully folks will forgive me for going a little rapid fire. Our team, one of the cases that our team has spent a lot of time on this year was actually filed in late 2021 about Montgomery County's practice of unconstitutionally incarcerating people facing minor probation and parole revocation hearings, probation, parole, revocation hearings over minor violations. The case is called L versus Montgomery County, where we filed in the Commonwealth Court suing the Montgomery County Court of Common Pleas and the Montgomery County's clerk's office on an issue that is not limited to Montgomery County. We found that Montco was among several counties in the Commonwealth who were detaining people for months at a time on relatively minor supervision violations. So that case is pending. It's been going through the litigation process for the better part of this year. And we have an outstanding injunction request that asks the court to order that defendants be provided with a preliminary hearing, which is also known as a Gagnon 1 hearing, within 72 hours of detention to assess whether further detention pending final revocation hearing is justified. And by justified, we mean that somebody is a serious flight risk or poses a risk to public safety. Those are supposed to be the only constitutional reasons under the due process clause to detain people pre-hearing. But we found that a problem with people just sitting there having their rights violated for months at a time. Another issue that we've spent a good bit of time on in the latter half of the year is turning back our attention to the issue of indigent criminal defense and the constitutional inadequacy of criminal representation for poor people, which continues to be a problem throughout Pennsylvania. It's the only state in the union that doesn't provide for state level funding for indigent defense. So Pennsylvania completely delegates the obligation to fund this constitutional right to the counties. So as things currently stand, it's each county's obligation to ensure compliance with the Sixth Amendment right to counsel. And based on our analysis, there are lots of counties falling far short of this obligation. So earlier this month, where Luzerne County appears to have a pretty acute problem that's coming to a head right now in their budgeting process. So we sent a letter a couple of weeks ago to the Luzerne County Council urging them to adequately fund indigent defense in their county. It's one of many public defenders' offices in Pennsylvania that is stretched too thin. They don't pay enough to fill all of their vacancies in the public defender's office. And the result is that people are constructively denied their right to counsel under the Sixth Amendment and Section 9 of the Pennsylvania Constitution. So we hope County Council does the right thing in Luzerne. I said turn back to this issue because the ACLU of Pennsylvania sued the same county a little less than a decade ago and won a Supreme Court order that required Luzerne County to lift a hiring freeze in their public defender's office. But the problem persists and it persists elsewhere too. So I think we're probably going to be working on that a lot in 2023. Then the last thing I'll mention is our recent successes in law reform efforts to address the problem of people being jailed for simply being too poor to pay court fines, costs, and restitution. In August, in a case where we offered an amicus brief, Commonwealth versus Lopez, Pennsylvania Supreme Court did not go so far as to say that people have to have court costs waived when they can't afford them, but did authorize lower courts for the first time expressly to waive court debt at sentencing so that people can avoid being jailed in perpetuity for court costs. And then more recently, the legislature expanded on the Lopez ruling by enacting Act 163, which allows all fines and costs to be reduced or waived when a defendant cannot afford them. So it's a huge tool. So our efforts going forward will be focused on making sure that the judges who make these decisions and can waive costs know that they can under the law now. So I think Rich can speak better to our bail litigation.
Thank you, Steve. Rich, I talked about the right to reasonable bail as part of the work that we do. And if you don't mind sharing a bit about that.
Yeah, so in April, we filed a case. It's called HC v. Chudzik. It's in the Eastern District of Pennsylvania in the Allentown Division. In that case, we challenged the cash bail practices in Lancaster County specifically, although this is a problem that we kind of see around the state. So for some background, in Pennsylvania, if you get arrested, typically your first contact with the judicial system will be a preliminary arraignment in front of a magisterial district judge. Excuse me. And at that preliminary arraignment, the MDJ will set the initial bail or terms of release. So under some circumstances, the MDJ can deny bail, but when cash bail is imposed, the purpose of cash bail is to secure the person's appearance at court whenever that is scheduled. But in practice, what we see is these cash bail orders that get entered in amounts that the person cannot afford. So in effect, it's just a detention order. And the MDJs are supposed to consider a list of factors that take into account the person's ability to pay. And in practice, these preliminary arraignments are often very short. They just take a couple minutes, and it seems like they're just arbitrary amounts that are imposed. And so people can't afford it and end up in jail, and they're detained pending trial. And keep in mind that these are people who have been arrested. They have not been tried. They're innocent until they're proven guilty. And it causes huge disruptions to people's lives. You know, people lose their jobs, they lose housing, it causes a lot of family problems. So in the case, we brought this as a class action. There are 7 named individuals that were detained on cash bail orders. The defendants are a handful of MDJs in Lancaster County, the county, and the warden of the county jail. The legal claims, there are 4. So there's a procedural due process claim. So basically, these individuals end up in front of the MDJ. They have no notice of what's going on, and they have no notice of kind of what factors are being considered when the MDJs make these decisions, and yet they lose their fundamental liberty to be free from detention. Second claim is a substantive due process claim. That's kind of related. It's, they're losing this fundamental liberty interest in being free pre-trial. And then there's an equal protection claim, which is based on the theory that because the MDJ has failed to take into account a defendant's ability to pay, it has the effect of discriminating on the basis of wealth. So basically, people who are wealthy and can afford the cash bail, they get to be free pending trial, where if you just don't happen to have enough money to pay, you get stuck in jail while you're waiting for trial. So those are some of the claims. And the last claim is a right to counsel. So current practice in Pennsylvania is you do not have the right to counsel at this preliminary arraignment, despite the fact that your liberty, your freedom is at stake. The case law actually is not very clear. So we're challenging that in this case, and we're arguing that there should be a right to counsel at this preliminary arraignment. And the status of that case, there have been motions to dismiss filed by the defendants. That's been fully briefed. There was a hearing last month. We're just waiting for a decision from the judge. We've started some discovery and hopefully that will get moving a little bit more quickly soon.
Thank you. I want to be mindful of the time, but I also want to turn to another important priority area for the organization, which is voting rights, right? We've been protecting voting rights forever, and this past year has been no different. We are deeply committed to ensuring that all citizens who are able to vote can indeed cast their rights to vote and have them counted. I don't think that's asking too much, but apparently it's too much for many people. So ergo, the decades and decades of fighting to ensure access, to eliminate barriers, to increase civic engagement, to protect those rights. So Marian, I want to turn to you initially. So we are so fortunate to have had you join our team and given your amazing background in this area and to head this work for us. And you have your work cut out for you, just in case you're not aware of that. So since the 2020 election, the institutions of our democracy and our democratic processes have been under relentless attack. Can you share with us what some of the significant cases in advocacy have been over this past year that we've done here at the ACLU?
Sure. Thanks, Reggie. So, as Reggie has mentioned, the institutions of democracy, especially voting, have been under attack. And the attacks have been coming from individuals and groups, elected officials and candidates who are sowing doubt and distrust in the election process themselves. And many of this distrust is based on conspiracy theories and innuendo. So our voting rights work is really two-pronged. One is advocacy work and also litigation. So I'd like to just briefly talk about the kinds of things that we did to advocate for against some of these attacks that did not result in litigation, but were important nonetheless. For example, before the spring primary, the district attorney in Lehigh County issued a press release and sent a letter to the election directors saying that he was going to post in-person armed detectives in person around all the drop boxes in Lehigh County to prevent fraudulent deposit of ballots. And he also admonished the election director and said that they didn't have a good enough notices about what was illegal activity around drop boxes. In Pennsylvania law, Pennsylvania law has been interpreted to mean that you can only drop off your own ballot, but into the drop box. But there are also provisions for voters with disabilities that they can designate an agent. So we sent a letter to the DA, first of all, advising him that his overbroad expression of the law didn't include the designated agent for voters with disabilities, so it was inaccurate, but also that posting armed detectives around drop boxes might cross the line into voter intimidation. Now, we didn't receive any reports during the primary of confrontation at the drop boxes, but we know that the DA did not replicate this for the November election. There were several lawsuits at various counties seeking to impose by court order the kinds of things that the DA was trying to do in Lehigh County, and those lawsuits were dismissed. So that was a good thing. The other thing that was happening, and as a result of it, just relentless, I feel like the election deniers have a bottomless pit of energy and funding to bring lawsuits. But as a result of several lawsuits, one of which caused counties to have to set aside mail ballots that were defective in some way, and mail ballots where voters forgot to write the date, and we'll talk about our litigation there. But counties were not providing notice to voters that there was some defect in their mail ballot and allowing them a chance to correct it. And some counties were actively telling voters that they could not go to the polls on election day and vote a provisional ballot to correct a flaw. So we sent a letter to 27 counties telling them, look, if you cancel the ballots, if there's a defect in the Shore system, that'll generate a notice to the voter. Then they can go to the polls and vote a provisional ballot to correct the defect. And we did hear back from 4 counties that they were going to follow the Pennsylvania Department of State's guidance on this matter. And we also, during our election protection work, did not get any reports of voters who were denied the right to vote a provisional ballot, But we were ready because we had our injunction papers all drafted and sent out to all our county attorneys ready to go in case we had to go into court and get an order to allow voters to vote a provisional ballot. I also want to highlight a success story from our advocacy in Philadelphia. Language access is a priority for making sure that voters who speak a language other than English have an opportunity to vote at the polls. And ACLU is an active participant with the Citizens for Language Access in Philadelphia, who have been advocating for Philly to expand the number of languages. Philadelphia is required under the Voting Rights Act to provide language access in Spanish and Chinese. But as a result of advocacy that ACLU and its coalition partners did, the Philadelphia City Commissioners unanimously approved a resolution this year to expand language access for Russian, Khmer, Vietnamese, Arabic, Haitian Creole, and Portuguese. And that's fantastic because they're not under no legal obligation to do it, but they are demonstrating a commitment to increase accessibility for voters who speak a language other than English. So now turning to litigation, I'm just going to highlight 3 cases. There's so many cases, but one of the things goes going back to what we're proud of, and I was so fortunate to work with both Rich and Steve on this case, and it's Migliore against Cohen, which was a federal case we filed at the end of January earlier this year to protect voters who forgot to write a date on the outer envelope of their mail ballots. And there was a long proceeding in the state court. First, they were going to count them, then the litigation ensued, and the end result of the state court litigation was that Pennsylvania law was mandatory and the counties could not count ballots where voters forgot to write the date. We represented 5 voters between the ages of 66 and 76 who had forgotten to write a date in Lehigh County. This was the municipal election in 2021. And the only race at issue was the race for Court of Common Pleas judge. And we argued that the materiality provision of the Civil Rights Act of 1964 prohibited the county from disenfranchising voters for failing to write the date. The defense was that there was no private right of action under the Civil Rights Act. Surprise, the Civil Rights Act has been around since 1870 and voters have been suing under it since then, but surprise, no private right of action. But anyway, in the third, it never ceases to amaze me, the arguments that we are faced with. But we won in the Third Circuit in a presidential opinion, a 3-judge panel unanimously held, including a Trump appointee, I might add, that timely received absentee and mail ballots must be counted even if voters forgot to write the date next to their signature on the outer envelope, which contains the voter's declaration. And the key holdings were that the Civil Rights Act of 1964 does confer a private right of action on voters to enforce its provisions, and that the text of the materiality provision, which states that no person acting under color of law can deny the right of an individual to vote because of an error or omission on paperwork that's a prerequisite to voting if such error or omission is not material in determining whether such voter is qualified. And in that case, there was ample evidence that the date was completely immaterial. We have received by deadline in Pennsylvania. The ballot has to be there by 8 p.m. on election day. And so if it's not there in time, the date has nothing to do with it. And when the ballots come in, the counties stamp date and time stamp their arrival. The case, I'll just note that there was a petition in the U.S. Supreme Court to stay the impact of the Third Circuit decision by the candidate that ended up losing and who was kind of guessing he was going to lose. But that stay petition was rejected 6-3 by the U.S. Supreme Court, and the ballots were counted and the winner was certified. But in a procedural move, the losing candidate then asked the Supreme Court to vacate the Third Circuit's decision because it was mooted, there was no meaningful appellate review. While we disagree with the Supreme Court, who did vacate the decision, there was no ruling on the merits. And so we'll talk about this when we get to what's ahead, but we have another case in the Western District of Pennsylvania on the same issue. Because of other litigation in Pennsylvania on this issue, which the Supreme Court failed, the Supreme Court, which is a 6-member court now because of the death of Justice Baer, deadlocked on the issue of whether the materiality provision requires counties to count ballots where voters forgot to write the date. I want to talk briefly about another case that is still pending that emanated from a subpoena. This is, again, election deniers trying to state that there was something wrong with the presidential election in 2020. And so the PA Senate, the Intergovernmental Operations Committee, an obscure committee of the PA Senate, issued a subpoena to the Pennsylvania Supreme Court, to the Pennsylvania Department of State, seeking private information from all 9 million registered voters in Pennsylvania. The subpoena sought the entire voter registration database, including driver's license and social security numbers. We intervened on behalf of voters to protect the fundamental right to privacy that is guaranteed under Pennsylvania's Constitution. That case is still pending, but we have prevented the disclosure of that information publicly so far, and we are keeping tabs on that. And one other, I'm keeping an eye on time here, but one other case that we were involved in an amicus capacity was the constitutional challenge to Act 77, which gave us mail balloting for all Pennsylvania voters. The Pennsylvania Supreme Court did uphold that constitutionality. I don't know if we have time to talk about another amicus we're getting ready to file and to protect the right of the voters. We do.
Do it in 2 minutes if you can, because I want to turn to Q&A.
I'm going to throw it to Steve to talk about the amicus we were about to file.
No pressure. I could do it in under 90 seconds. So this has to do with the effort to impeach Philadelphia District Attorney Larry Krasner, which originated from the outgoing General Assembly in Harrisburg. And, as Reggie mentioned, we are nonpartisan. We don't support any particular candidate. And that doesn't change with the Krasner issue. What we are supporting is the Philadelphia voters' rights to have their chosen candidate in office, unless there's a really good reason to impeach him between elections. And Krasner was pretty clear on what his platform was and was reelected by about 70% of Philadelphia voters in the last election. And so we're putting in an amicus brief to speak against impeaching him based on what boils down to policy decisions and his approach to prosecution, which is not, we contend, a high enough, doesn't hit the high bar of misbehavior in office under the Pennsylvania Constitution. So about a week and a half ago, Krasner and his team filed a petition in the Commonwealth Court seeking a declaration that continuing with the impeachment process after the new General Assembly convenes is unconstitutional. And we're filing our amicus brief in the next 24 hours. So you all are getting an exclusive. We haven't done this yet. If you see me looking away from the Zoom screen every once in a while, I'm checking on the status of the brief. So in the next maybe 12 hours, we'll be filing a brief that from the perspective of the voters' rights and the issues that voters care about, they should have the ability to select and have their candidate, even if that candidate has policy positions that conflict with what people outside of Philadelphia might want.
Well done, Steve. You did it in exactly 89 seconds. Off to a good start. So I want to turn to the Q&A because we have questions from the audience. But before I do that, I want to give the second password in order to receive CLE credit. And that is racial justice. Again, all caps, I think. So thank you all very much. So now let's turn to some Q&A from the audience, and I'm just going to read the ones that I have for me. I had that I can see right now. There may be others elsewhere, but these are the ones that I can see. So a question from Reverend Dr. Roger Thomas is, what's your plan for gerrymandering activity in 2023? Pennsylvania did well in Congress, and Pennsylvania House did very well. PA Senate, not so much. So, Marian or anyone want to take that question?
Well, so first of all, the ACLU Pennsylvania historically doesn't get involved in redistricting issues, although at ACLU National, the Voting Rights Project, they do get involved on behalf of voters who where gerrymandering may have a racially disparate impact. But as far as if there were to be a statute or a constitutional amendment proposed, for example, what they call judicial gerrymandering, which having districts for our Supreme Court elections, we would definitely oppose that kind of legislation rather than our current system. But at this point in time, unless there is some kind of claim of a racially disparate impact, we would probably not get involved in any redistricting or gerrymandering issues.
Thank you. I'm going to move on to the next question. It says, looking ahead, do you see priority issue areas changing or shifting your focus? That's a good question. I'm just going to answer that myself. So we went through a strategic planning process that helped us identify the 3 core priority area issues that we're working on, which I identified earlier as decarceration and police reform and voting rights, but leaving us the space to be able to respond to emerging threats, such as in reproductive rights, inclusive education, and the like. So we have flexibility to take on new issues. I think that we'll probably be with these issues for a bit, but we always want to be on the lookout to make sure that we're doing work that is relevant, and then have the ability to respond quickly to the issues that are in fact emerging. So I think we struck a right balance for now, but are always open to revisiting those priority area issues as appropriate. All right, so I'm going to ask the next question from an audience member. What has been the quantitative progress on reducing incarceration, and what is the forecast going forward? Is there anyone who can take that question?
I can answer part of it, and I do think, and stop me if anybody else has a better answer, but I think it's something that we have not completed is the effort to, identify how impactful our efforts so far have been and measure that up against, what we established as a goal to reduce mass incarceration in Pennsylvania during the strategic planning process. But, one kind of anecdotal example of the impact is upon filing of what we think is the impact. So it could be correlation, not causation, if you're being strict about how we read data. But upon filing of the Lancaster County bail case that Rich was talking about, we could see an almost immediate reduction in bail in Lancaster County and elsewhere. So, I think, I'm assuming a little bit that there must be a connection here. In the absence of any other explanation, I think it's a testament to the impact that we can have when we weigh in on an issue, and that's before the litigation has really gotten up and running.
Thank you, Steve. I think also, hasn't the Pennsylvania prison population decreased in the past several years? I mean, we can't take all the credit for that, but I think it might be appropriate to take some of the credit. I want to talk. I want to go to the next question, which is about voting rights. And the question is, what role does the Voting Rights Initiative play in the lead up to the 2024 elections? Were there any insights gained from the midterm elections that are influencing your approach?
Yeah, so I think one of the things that we did internally and with our coalition partners was to try to anticipate or plan ahead the attempts that what we call election crises, where there would be attempts to subvert the outcome of the election. And some of the things that we planned around were, excessive challenges to mail ballots, or counties that would refuse to certify the results or delay certification of the results for arbitrary reasons. We also planned for excessive voter intimidation at the polling places or around drop boxes. And I feel like we didn't see what we planned for, but all of the process and the planning that we did in the run up to the 2022 elections can carry over in our preparation for 2024. The difference between 2022 and 2024 is the Electoral College, because we don't have the tight deadlines in 2022 that we will have 2 years from now. In other words, there's a safe harbor deadline, states' results have to be certified, and attempts to delay that certification could influence the outcome of the presidential. So we are cognizant of that, and all of this is, I would say, everything we did for 2022 was rehearsal for 2024.
Thank you, Marian. I want to. We're running out of time. I want to give the panelists the opportunity to talk about what's ahead. But before we do that, so if folks can hang on for a couple minutes after 5, I want to answer this one question from someone who's with us today, who says, my transgender niece moved in with me in Pennsylvania, applied for Medicaid. Application asked for sex at birth. Also, she applied for Pennsylvania's driver's license, and the license shows an F. She's not changed her name yet, F for female, but her voting record showed an M for male. What are you doing to help transgender people? Is that a question someone can take on?
Well, I can talk about the forms, and then Rich and Steve can certainly talk about some of the litigation we're working on. But so as far as the when people are in transition, it is difficult on the forms to make sure that the IDs and, for example, driver's license match the presentation. So, but one thing we did this year, there was an issue with voter registration where PennDOT has M, F, and X for non-binary, but the voter registration form didn't have the X, and we were able to get that changed internally very quietly, actually, so that the information from the driver's license that is used in voter registration would match. I think that these areas where the forms are not accommodating is an area that we could do more advocacy around. But Steve and Rich jump in on some of the other.
So one thing is just to uplift, some of what Rich was talking about earlier to the broader question, what are we doing about trans rights? Part of the answer to that is what Rich is doing and Alex is doing in the school district space. Another thing that we're working on is name change issues broadly, and more specifically, we have one pending litigation currently on behalf of a trans gentleman who is having more trouble than is legal in getting a legal name change in Montgomery County. Not to pick on Montgomery County too much, but our client tried to get a name change, asked for a petition for a waiver of, there's a Pennsylvania statute that requires anybody seeking a legal name change to publish their name change before getting it granted in 2 publications. And that is very fraught for trans folks. And so our client, like many others, petitioned for a waiver of that requirement because he has a legitimate fear of being harassed. There are threats to safety for people who have to publicly out themselves like this. It's something that in some counties is routinely granted. In the particular county where he applied, it was not. So we've appealed that up to, we have a pending application before the Pennsylvania Supreme Court. And there are also some legislative efforts to try to get that publication requirement out of the Pennsylvania statute. And then on a more granular level, we have an all-star trans rights coordinator, Naima Sanchez, who works with every community partner you can imagine, and recently ran a name change clinic at University of Pennsylvania Law School, which many of our folks help staff, and it's a constant effort, both for Naima and the other organizations that she works with and we partner with to help folks with these types of issues.
Awesome. Thank you, Steve. So that was our final official question. I want to, as we are bringing this to a close, being mindful of time. Thanks everybody for sticking with us for a couple of minutes longer. I want to do a couple things as my colleagues are contemplating what's ahead in like 1 minute each. I want to thank everybody for joining us this afternoon, and special thanks to Fagri Drinker for sponsoring the CLE for today's session. So thank you, Fagri Drinker. I got a notice that I was signed out. I think I'm still on. Is everybody still here? Perfect. In 1 minute, can each of you talk about what's ahead?
Sure, I'll go first. It's not a very exciting answer, but we talked about a lot of the more kind of high-profile things, but just want to highlight that there's a lot of stuff that we do that kind of gets resolved quickly. Steve and Marian alluded to it a little bit, and I'm sure we will continue doing that. A lot of issues that come to us, things like First Amendment issues, so signed ordinances, surprisingly, are always a problem. So we're frequently writing letters challenging signed ordinances. Also, student speech issues frequently come up, and often those are resolved by letters. So I'm sure we will continue to do that as well. They just don't get a lot of attention, but it's still very important.
Great.
I'll just jump in. We're still litigating the issue of whether under the Federal Civil Rights Act, voters who forget to write the date on their mail ballots can be disenfranchised. We have a new case we filed the Friday before the election in the Western District of Pennsylvania. So hopefully we'll get good clarity on the law around that, where you don't have to litigate this on an emergency basis. But in voting rights, we're going to be doing advocacy at the county level, urging counties to adopt best practices. And then because of the changes in the legislature, we're hoping to get clarity in the law around mail ballots, repealing certain things, and it just, putting in processes to make voting easier for voters.
Thank you.
I guess that leaves me. So in addition to all of the work that my colleague just mentioned, I think we'll likely see a bit of an uptick in litigation work around our policing and decarceration priorities in between elections this year. So ongoing work on the indigent defense and revocation detainer issues I described before. One thing we didn't talk a lot about is litigation work in policing. I think we are likely to file something and continue working with our community partners to address police mistreatment of Black and Brown folks around Pennsylvania.
Thank you all very much. That was a lot of, you covered a lot today. Shows how busy the organization has been, but again, doing really high level, top notch work. So thank you all so much. And everybody who participated today, thank you for joining and sticking with us. If you agree that this was a great session today, we would invite you to make a gift. If you're able to do so, please visit www.aclupa.org/donate, www.aclupa.org/donate to make a donation. And also there you can find ways that you can participate as well. So thank you so much. Please consider a gift and have a good holiday season.